So this week we're going to be looking at the judicial branch. So this video is really going to go extend information beyond the textbook. So make sure you read the textbook probably maybe before you watch the video. So if you haven't, I would recommend reading the textbook first. This video and this week's discussion, we're going to focus on the high level information. So the structure of the court, judicial decision making, selection of the justices. The chapter will get into a little bit more details and specifics, especially juries, prosecutors, defenders. We're going to get into that more when we talk about crime and punishment next week. So I'm actually going to pull parts or pieces of chapter 9 and then move them into next week with the crime and punishment because I think it kind of fits better with that information and tying it in there. So again, this week we're really going to focus on the high level structures. So that's the portion that you should focus on in the chapter. And again, most of what I'm going to cover in this video is not covered in your chapter. It's supplemental or additional information to help you understand sort of the bigger picture. The judicial branch is generally considered the most popular and legitimate of the three branches. Remember, the legislative branch, both Congress and state legislatures, are usually the least popular. One of the main reasons is because it's viewed as the least political, but it's also important because it has to be viewed as legitimate, which we'll be talking about now. So there's the idea of a mysticism of the court, or the notion that the public has to believe judges are dispassionate, objective, and impartial. We must believe they are above human mistakes because they can literally be making life or death decisions. Therefore, their legitimacy is often based on this shared belief, even though we probably know they are mere humans prone to mistakes. And if we're looking at individual judge or justices, we'll likely see that. But when we're looking at the institution as a whole, we sort of cater to this grander belief. This all comes from research done by Siegel and Spaeth. They had an article back in 1994 and then a new revised book in 2002 called The Supreme Court, an Attitudinal Model. And this philosophy that devices are created that infer this respect and reverence, right? So this mysticism in practice. And you can think of a number of them. So just kind of a few, right? The secrecy and mystery of their decision making. The ritualized processes of, the judge sitting above everybody else, having to rise before the judge comes in and rise when the judge leaves the courtroom. All of the professional jargon that's used, so that the everyday person can't really pick up and read most legal arguments and kind of really understand them. And then things just as simple as having that black robe, right? So they're all dressed the same. Again, there are variations, especially at the state level, but for the most part, right, we think of a judge, we think of somebody in a black robe, and just that simple symbolic statement, right? It's making a statement of sort of taking away from their individualized identity and sort of making them this collective, right? This mysticism, this idea, again, that they're above just the everyday human. Of course, they point out that's not the reality, but the public perception is necessary, which is why the public can get upset if a judge is seen as being political. However, they're often forced with interpreting policy, and courts often are required to answer political questions, even though they will try to avoid them whenever possible. And I really like this cartoon because I think it's an accurate depiction of how most decisions are usually analyzed. It's a good decision if I like it, and a political one if I don't. And it's a bit fair because most people don't have the skill to read legal reasoning. Again, it's not written at an everyday person sort of level. So judicial activism is a belief that a judge is making policy rather than just interpreting it or interpreting the laws surrounding it. So it's anytime someone's using the term judicial activism, they're basically saying that they think the judge is acting in place of the legislature. Courts use precedent or the use of prior decisions to help guide their future decisions, and basically any decision they make sets a precedent for future cases. Often you'll hear the term, or you might hear the term come up from time to time, stare decisis, which is just the Latin for to stand by things, or again, a Latin phrase for precedent. And again, the judges, depending on precedent, will depend on specific cases. They, as a rule, most judges do follow precedent, no matter what's actually said in the public or even by themselves. The idea of following precedent is fairly well followed. But of course, there are times where precedent is overturned. And a really great example would be Brown versus Board of Education, overturning the very horrible, separate but legal decision in Plessy versus Ferguson. And of course, we have the recent Supreme Court decision overturning Roe versus Wade. So this picture describes like a simple structure of the courts, which shows that even cases starting at a state trial court level can end up at the U.S. Supreme Court, but only if there's an issue involving federal legislation or the U.S. Constitution. The U.S. Supreme Court will not interpret state laws or state constitutions. The highest court in each state is going to be the ultimate decider of state laws and state constitutions and how they're interpreted. Most of the the highest court in the state is referred to as the state Supreme Court, with only a couple of exceptions. New York being one of those that has a very strange system, with their trial courts being actually called Supreme Courts. Their highest court is the Court of Appeals. It is one of the 39 states with intermediate appellate courts, which are referred to as Supreme Court Appellate Division. Referencing a case, if just in case you're ever reading a case from New York, it's a bit confusing. There are 11 states without intermediate appellate courts, and they tend to be your smaller states, so they just appeal directly to their state Supreme Court. It is important to note, as your book does, that not a lot of cases originate at the federal courts, but a lot more originate at the state level. So there are a number of due process rights guaranteed by both the U.S. Constitution and the Bill of Rights, incorporated to the states by the 14th Amendment. And all state constitutions also have procedural guarantees for those accused of a crime and brought to court. As the previous slide showed, trial decisions can be appealed through the court structure. We'll look at that a little bit more. Every criminal is afforded at least one right to appeal as long as their case reaches that threshold, that lower threshold. For most, this would go to the Intermediate Court of Appeals. That way, they would have mandatory jurisdiction, which basically just means the court has to hear the case. But after that, and most high courts have discretionary jurisdiction, which means they can choose whether or not to hear the case. So you get your one appeal, but you can hear about people, right, who are appealing over and over, and sometimes they can be afforded multiple mandatory appeals. But usually after the first appeal, it's just discretionary, right? The court can choose whether or not to hear it. So jurisdiction just means the court's ability to hear a case. So there's actually lots of different types of jurisdiction. This is whether or not a court has the jurisdiction is established by the laws setting up the courts. So even trial courts have to have the correct jurisdiction in order to hear a case. Protections are not just afforded to criminal cases, but can also be used to protect other civil liberties. There are a lot of instances where a court has to decide between two individuals both claiming their civil liberties are violated. Remember back to week 1, government both protects and limits our freedom. That is because they decide when our rights or freedoms begin to interfere with the rights or freedoms of others and therefore will be limited. This is often decided by judicial review, which is a power given to the courts, specifically the U.S. Supreme Court in Marbury v. Madison, making the U.S. Supreme Court the ultimate decider of all. But all courts have this ability to some extent. Marbury v. Madison is a very interesting case. I've included some slides and information in the optional slides if you're interested. I do recommend doing it. The history behind the cases, to me, is probably the most fascinating of any case to go before the Supreme Court. Just how all of the characters are both involved in leading up to the case as well as the case itself. All right, so continuing on sort of judicial decision making, I'm using the Supreme Court justices because these two have become the face for each position. Before Scalia's death, they spent over a decade traveling around having this debate, so there's lots of videos out there if you want to learn more. This often comes up with any judge at the appellate level, and if they're looking to move up to a different or a higher level, is how do they interpret laws or constitutions. So originalism is going to interpret based on the intent of when it was written, and sort of has the philosophy that if you want to expand rights, you do it through the legislature, not through the courts. Evolutionists, although they've not really settled on that name, so you hear many different names, have a philosophy that looks more at the current values and circumstances and are more likely to use the courts to expand rights. So judges and justices really are not allowed to be political, and depending on the state, these rules can be very, very strict. But even in states like Illinois with partisan election, judges and justices are just generally referred by their ideological labels. So conservatives tend to be originalist or strict constructionists, kind of following along with Justice Scalia. Liberals tend to be more activist, believe in the living constitution, although again, that term is not always liked. Falling sort of in the vein of Justice Breyer, again, evolutionist is another term that's been used. Although how much their ideology will actually affect their decision is really going to depend on the individual judge or justice. Some judges and justices just really value precedent and following the rule more than their ideology, and then that will come through in their decision making. I'm not going to spend a lot of time on this slide, and you don't have to know this, but it just helps kind of further explain everything, especially when it comes to judicial interpretation. So on the left side with the blue, these are the tools that justices use to interpret um, legislation or constitutions. And those with a conservative ideology believe that only the first four should be used, and the last two should never be used. While liberal justices will use all six, but the last two are often the ones viewed as the most important in their decision making. So keep in mind, judicial systems are political, especially at the state level. And this is increasingly so with increased attention paid to judicial selection and retention. Despite the information I just gave, there's a lot of evidence that judges tend to make strategic decisions, especially at the lower levels. This is often affected by the method of selection and if they're up for retention elections or whether they get life tenure. Their responses to cases have been shown to be affected by this, specifically giving out stiffer sentencing or punishments if they are up for re-election or retention re-election that year, or even going back 2 years, because they don't want to be accused of being soft on crime, an accusation that's very easy to make by opponents, and one thing the public tends to understand about the judicial process and tends to care about. All right, so that kind of hits a lot of the high level, and again, as I mentioned at the beginning, a lot of this is additional information not in your textbook. So again, focusing on legitimacy, the structures of the court, judicial decision making, and then your activities are actually going to play off of some of the other information from your textbook that, again, your textbook does a really good job, and then we're going to use the topic discussion and applying the topic to further look at it, which is looking at judicial selection. We'll look at the Illinois court system specifically a little bit, as well as judicial retention elections. So those are kind of, those will be captured more in our activities. And again, the ideas from this video are kind of just, again, broadening that understanding of the courts and kind of looking at the larger picture.